Are you curious about what you can't do as an executor of an estate? Well, stick around because that's what I'll be talking about today. The executor of an estate has a host of responsibilities, from notifying heirs to managing assets. But an executor's authority isn't endless. There are limits on what an executor can and cannot do. If you've been named an executor, a couple of basic rules of thumb are that you can't do anything that disregards the provisions in the will, and you can't act against the interests of any of the beneficiaries. Sounds pretty straightforward, right? Sometimes it is, but depending on the complexity of the estate, figuring out the bounds of your role as an executor could be challenging. Now, as an executor, you have a fiduciary duty to the beneficiaries of the estate. That means you must manage the estate as if it was your own, taking care with the assets. So you cannot do anything that intentionally harms the interests of the beneficiaries. As an executor, you cannot do anything to carry out the will before the creator of the will passes away. And neither the executor nor the beneficiary have any rights with regard to the estate before the testator passes away. Just because you're named in the will doesn't mean you get to start making financial decisions about how Aunt Mary is handling her assets. You cannot sign an unsigned will on behalf of the deceased. If the deceased died without a signed will, then the deceased died without a will. No one else can sign it on their behalf, and the estate will be managed in accordance with the state's law of intestate succession. You cannot take action to manage the estate prior to being appointed as executor by the court. So you have to fill out the petition for probate. You may have to do some basic analysis to determine what's in the estate, but taking action beyond that, selling assets or making payments, is not allowed until the court has approved your petition and appointed you as the executor. You cannot sell assets for less than fair market value without agreement of the beneficiaries. Your fiduciary duty requires you to treat the estate's assets as if they were your own assets, and to take good care that the beneficiaries receive the portion of the estate indicated in the will. Parting with assets for less than what they're worth, for instance, might be I'm offering them at a discount to friends. That's in direct opposition to the duty. You cannot change any provisions in a will. Just like you can't sign the will, you can't change provisions in the will. And if you really like your cousin and you agree with him that he should have been named in the will, that's unfortunate. He can file a petition with the court contesting the will if he's an heir at law, but you have no authority to make changes to the will. You cannot stop the beneficiaries or heirs from contesting the will. When beneficiary or heirs contest the will, it's never fun for the executor. However, it's their right to do so, and you can't stop them. Mismanaging an estate is not without consequences. If an heir or beneficiary believes you are not appropriately fulfilling your legal obligations, they do have the right to file a petition with the probate court to get a full accounting of the estate's assets or to have you removed as the executor. Serious violations could also result in your being held in contempt of court or being the subject of a civil lawsuit. Of course, most individuals who serve as an executor take their responsibility very seriously and handle the estate with care. I hope you found this useful.